Good morning. I'd like to welcome everybody to our May 1st Planning Commission meeting. I'd like to call this meeting to order and ask Mr. Slade, if he would, open us up with a word of prayer.
Father, we have so many reasons to start this meeting by thanking you for everything that you do for us, how you bless us so abundantly, provide for us, Lord. Thank you for what you give to us, the skills and the abilities that you give to us, a place of service that you provide for us. Help us to never take for granted, Lord, that all of the good and perfect things that we enjoy, they come from you. And so we turn our praise to you this morning, and we thank you for the day you've given us, and we ask for your presence here with us today as we attempt to do the business of the county. Father, to make good and wise decisions that are in keeping with your will and benefit all of the citizens of our county. Thank you, God, and help us in Christ's name.
Amen.
Amen.
All right. Consideration and approval of our April 3rd minutes.
Motion approved. Second.
Brad made a motion, Scott seconded the motion. Any further discussion? All in favor?
Aye.
Motion carried. Old business. Have any old business?
No, sir.
No old business? All right. New consideration.
Yes, sir.
Okay.
We've got a few.
Okay.
The first one up is Pierce Construction. They're seeking a conditional use permit to mine an additional 15 acres off of a 144 acre parcel located on Star Road. They are currently operating under an approved conditional permit which covers a total of 25 acres. This is an aerial view of the property. View of the current mining areas with the ingress and egress along with the new proposed area and the white outline there. That's the new section. And this is a view of the property. And these are some of the surrounding properties. Next up, we have Miss Emma Boone is seeking a conditional use permit to operate a behavioral health service and community education program on the property of New Hope Missionary Baptist Church at 935 Highway 49 North. This is a 16.69 acre parcel that is zoned A1. This is an aerial view of the property. New Life Counseling, DBA Boone Behavioral Health Services, offers a comprehensive approach to education, therapy, and consultation, focusing on psychosocial rehabilitation and day treatment for all ages. Services are delivered by experienced, qualified therapists and support staff. This is a picture of the property. It's a separate building from the main church. And these are surrounding properties. Well, we do have a picture of the church here. Proposed hours of operation are Monday through Friday from 8 a.m. to 6 p.m. Weekends will be reserved for individual therapy services if needed. Here's some more surrounding properties. All right, next we have Jeffrey Lee Coy is seeking a conditional use permit to place a 2025 16 by 80 manufactured home on a 3.46 acre parcel on Trickham Bridge Road. The property is zoned RE1 and surrounded by family land. Here's an aerial view of the property. And this is a view of the property. Mr. Coy intends to reside in the manufactured home temporarily while he saves the necessary funds to construct a permanent dwelling on the same property. Here's some surrounding properties. Tiffany Lindsay is our next conditional use permit. She's seeking a conditional use permit to place a new manufactured home on family land located on Andrew Chapel Road. This is family-owned land totaling approximately 27.6 acres. The family intends to deed out 3 acres for her home site. Due to severe health issues, including seizures and tumors, Ms. Lindsley requests approval to place a manufactured home under a hardship clause to live near family for support while maintaining some independence with her children. And this is an aerial view of that. And this is the property. And surrounding properties. Next up, we have Jose Serra. He's requesting to rezone 4 acres from RE1 to C2 at 3753 Highway 471. Mr. Serra intends to utilize the property for the future development of an office and laydown yard to support the operations of his construction company. And this is an aerial view of the property. The proposed use aligns with adjacent zoning and intended commercial nature of the area.
Ryan, is that C2 in the red?
Yes, yes, sir, it's C2.
The laydown yard, typically outside storage is not allowed in C2. Has there been any discussion about looking at C3 for this parcel?
I don't really know exactly what he's intending for this laydown yard. We've got to talk about that and
Right.
see,
Right.
because it could be we don't want it to go into a C3.
Right. No, I understand, but with it being outside storage and knowing on the front end and doing a rezoning to C2, knowing on the front end that it's gonna have outside storage, obviously that's problematic.
Yes.
Okay.
This is a view of the property. And these are surrounding properties. All right, the next up we have 43 Farms LLC. They're seeking to rezone a combined 4.63 acres from A1 to C2 on Highway 43. Their intentions for the subject property is to be developed as a Penn's restaurant. Direct ingress and egress access will be from Highway 43 North. And this is an aerial view of the property. This is the zoning map. This is a picture of the property here. And surrounding properties. That's all
How
we
close to
have.
25 is that?
I think it's about 2 miles.
It's closer to Tommy's, I guess.
Yeah, I think it is closer to town.
This time we need to set public hearings.
Need a motion on item 1 first, it's May 5th setting.
I'll make a motion to set.
I second it. Brad made a motion, Steve seconded the motion. Any further discussion? All in favor? Motion carries.
I make a motion that we group 2 through 6, and I make a motion to set those public hearings.
For May the 15th.
May 15th.
And I'll second his motion.
Steve made a motion to group 2 through 6 for May the 15th. Scott seconded the motion. Any further discussion? All in favor?
Aye.
Motion carries.
Gentlemen, it looks like we have one item under our nuisance property considerations today. This will be the Norris Jean Pitts nuisance property consideration, 150 Wildbird Lane. This is a District 4 parcel. We'll open that public hearing. I'll ask Brian to demonstrate with the photos. I'll ask Mr. Pitts or anyone on behalf of Mr. Pitts who is intending to speak. to be prepared to come forward and address the board.
On February the 14th, 2025, we received a complaint for rubbish, garbage, parking, and storage of vehicles, and someone living in a recreational vehicle. These are the pictures taken on February the 18th, 2025. A nuisance letter was mailed to the property owner and received on February the 19th. These are the pictures taken yesterday. The hearing notice was received on April the 4th. Colby has not heard from the property owner.
Is the camp, the small trailer gone?
Yes, sir.
Look like they tried to clean it up a little bit.
That's the old picture.
Yeah.
All right.
This is the
Circle
old.
back around on the new pictures, newest.
These.
I'm satisfied that they have made more than just an attempt.
Yeah, it looks like they have made an attempt to clean up,
Yeah.
you know, some.
Norris Gene Pitts. Is he here? Anybody on behalf of Mr. Pitts? Okay. Gentlemen, I don't see anyone here on behalf of the property owner present. The supervisor, I hear what you're saying. Are you asking that we not take action today, that we continue to monitor?
Yes, sir.
All right. Mr. President, we would not need any formal action. We just need that the minutes of this particular public meeting will reflect that the board has taken no action. The board will continue to monitor the property, and we will expect a report 30 days hence from our community development office concerning the condition of the property at that point. And if everyone is satisfied that the property is now compliant or continuing to get into compliance, we can end the matter at that point.
Okay,
We'll revisit this on our next planning commission agenda.
okay.
Okay. That public hearing is closed.
That's all we have,
Is
John.
that all you have? Our next meeting will be May the 29th at 9 a.m. Need a motion to adjourn.
So moved.
Second.
Scott made a motion, Brad seconded the motion. Any further discussion? All in favor?
Aye.
Motion adjourned. Now we'll call to order the board meeting. First, we have public comments. Ms. Wanda Brown, you'd like to step forward? Please,
Yes,
ma'am.
ma'am, if you don't mind.
And state your name and address, please.
I am Wanda Brown at 1291 Wade Patrick Road, Brandon, Mississippi.
Okay.
And, in 1980, I bought a piece of property there. I chose that property because it did not have restrictions. I wanted to do with that property what I wanted to do. I live in the country, so I am concerned with all the new ordinances, restrictions you might say,
Right.
that I might be facing in the near future. Because of rezoning, I'm afraid that I may not know that you have that in mind.
Right.
So I wanted to publicly say that I need more information before y'all make these decisions of rezoning or new ordinances, restrictions. I've lived in a manufactured home all of these years. I keep it nice. I update. And now you're saying I can't even buy or sell something on my property to another Rankin Countyan, or even give it to them. I don't know why you're restricting use of my property again, which I bought years ago, with the knowledge that there were no restrictions. Please take it into consideration, because I would just like to live in peace. I was just happily going along my merry way, you know, and things are happening that we're not aware of beforehand. Thank you.
Yeah. Now, would you like to address anything, Mr. Slade?
I was, you saw I was
Right.
preparing myself to give a response. Number one, I want to say thank you to this lady. Thank you for coming in and interacting with the Board of Supervisors and expressing your concerns directly to them. That's a very effective way to help us understand how we do things, how we do them, and what we intend to do, and making sure that folks know. We hear that, and so we want to do everything that we can to improve that part of our process. Let me say on the front end, this is probably not a consolation, but how we do our notifications to the public as it relates to changes in our ordinance complies strictly with state law. We do it exactly as the state legislature tells us we have to do it. And the adequacy of that notice, we will certainly want to address, but it may mean that we've got to have some action by the state legislature to improve that process. Because what we did is exactly compliant with what the state law requires, okay? Again, we can talk about the adequacy of it, but that's a state law requirement that we follow. We do it just by the book, okay?
Doing the minimum.
Well, but the state legislature defines what is the bare minimum, so we follow state law, okay? Second point, and I want to address this head on, because there's a good bit of misinformation. Nobody's surprised by that. There's a good bit of misinformation that's been circulated, and it needs to be addressed directly. The first and foremost issue, you raised it. You said the new changes to our zoning amendment will prevent you from being able to sell your property or transfer your property, or even prevent you from being able to continue living there as you have for many years, and that's simply not true. Nothing that the Board of Supervisors has done will cause anybody that has a manufactured house on property today to have to change anything. It's called a non-conforming use. Many times we refer to that as grandfathered. If the trailer is sitting on property today, it is grandfathered. It doesn't have to be changed out. It doesn't have to be, you don't have to go get a newer unit and bring it in there. You can stay right where you are in that trailer. And as long as there are not significant changes, for instance, a fire results and the trailer itself is destroyed beyond 50% of its value, if that happens, then yes, the unit does have to be replaced, and it will have to be replaced with a conforming unit. But if that unit is just sitting there, you do not have to change one thing. It can stay there for the rest of its useful life, or until you go on to glory. It can stay there. Where things get also mixed up is, what about if I want to sell to someone? What if I want to give it to someone? Again, under our rules for grandfathering, a simple change of ownership does not destroy the grandfathered status. Let me repeat that. A simple change of ownership does not take away the grandfathered status. So if you want to sell it to your neighbor, they can stay right there with that same unit, and it is the same as if you were still sitting there, okay? Where things get confused is, what if I want to upgrade? What if I want to expand? That's going to require some communication with our community development folks, and we need to take a look at what exactly are you intending to do, because if there are substantial changes, it may cause that particular unit to lose its grandfathered status. If a tornado comes through and takes out a number of units, those are gonna have to be upgraded with compliant units, units that are 7 years old or newer under the current regulations. So, again, if you are not intending to change anything, you don't have to change anything. Hopefully that will, now that that's clear, that will provide some level of peace to you that, that this is not going to really impact you in terms of your ability to stay where you are without having to make significant changes, or your ability to transfer ownership of that, simply to transfer ownership to another party. That nothing we've done affects either of those. Yes, ma'am.
If I chose to get a new mobile home, what do I do with the old one?
That unit will have to go. And whoever you're dealing with will need to determine what can or should I do with that unit. If it's older than 7 years old, it's not gonna be able to be relocated anywhere in Rankin County. It's gonna have to go somewhere else. But that would be the responsibility of whoever you transfer possession of that, of the existing unit to. That'll be their responsibility.
Anywhere but Rankin County.
Yep, under the current regulations, if your current unit is older than 7 years old, then yes, it cannot be relocated to property on Rankin County.
Okay. Next, we have Mary Brewer.
Ashley was kind enough, let me get there. I'm Mary Brewer, and I live at 2191 White Road, almost the end of White Road. Ashley was kind enough to explain that the property I was concerned with, y'all didn't actually rezone, that it's going to become a small venue place, and that's great. Have no problem with that. She also said there were 2 other things I could ask you about, so I was gonna ask you about that. Several months ago, dead trees along White Road were cut, big white X's, and work stopped before it got to us. And we've got 2 or 3 very large trees that are not safe for us to take down, of course, that are gonna go across the road, even Mount Zion that's across the street from us. I mean, it's gonna kill somebody or really cause a bad traffic accident. And my husband had talked with someone, and they said that grant money had run out. She also said that Mike Harrison, I'm not sure who Mike Harrison is, might be a good person to talk with.
Well, we've got some crews that's back in that area. We're trying to address this, and I know where you're talking about. And, but we do have some money, you know, to continue cutting the trees.
Right.
And we do have some people back in that area, you know, today as we speak, you know, cutting them. Right, so we're trying to get to them, you know, cause it's, you know, the whole county's in that same predicament, you know. So I know everybody's trees are dying, and all of them can be a hazardous and falling, but, you know, we are addressing that as quick as we can.
Yeah, and these are right on the right of way, right on along the road.
Right.
The other thing really quick, I was wondering what the utility work is along, beginning of White Road, closer to Florence, coming out this way. Do we know what's?
Right, that's the C-spire.
C-spire.
Oh,
Yeah.
okay, all
Coming
right.
down.
All right.
Yeah, and,
Put the fiber
Sure.
optic in, and energy will be coming along and redoing the power lines. So,
Okay.
all right. And are you satisfied with the venue?
That's
Yeah,
fine.
right,
That's
yeah.
fine. That's great. It's beautiful, that little
Right,
area that they,
right,
yes.
okay.
Thank
Yep, and
you.
that-
I
all
appreciate
right,
it.
thank you, ma'am.
Mr. President, this is a good opportunity to remind everybody, you know, the county is not in the utility business. We don't regulate utilities, we don't control utilities. The interplay between the utilities and the county relates to how they enter into the county's road right-of-way. So when they install utilities in our road right-of-way, we get to address and permit how they do that. But utilities make their own decisions about where they're gonna go next, or what they're gonna install, and to some degree, how they're gonna install it. That is not something that the county regulates.
The Public Service Commission, which is a state elected official, the Public Service Commission provides regulation to some degree for how utilities operate. Okay, so I just wanted to make that clear. The connection with the county is typically it just has to do with how they are in our road right-of-way and how they relate to county operations in the road right-of-way. On the dead tree issue, I wanted to remind everyone, we have to be very careful about not getting outside of our road right-of-way to address dead trees. We have to be very careful about that. And so I want to remind folks, don't assume that a given tree is in the legal jurisdiction for the county to address. It's not always clear. When you ride up and down county roads, White Road would be an example. That road was developed long ago, probably as a logging road. There's never been an established right-of-way, or what right-of-way has been established is kind of haphazard. It's not automatic. You can't just drive down the road and say, well, I know exactly where that right-of-way line is, so I know that that tree or that tree or that tree is inside or outside the right-of-way. It takes more work than that a lot of times. And so I just want to remind our folks, we got to stay in the road right-of-way to deal with trees, and anything that's outside the road right-of-way, we have to be very careful about that, because people can go to jail for making the wrong call. And so we're very careful about that. On the funding, you guys have already voted unanimously to provide additional county taxpayer funds to address dead and dying trees. Those funds are precious. Those are tax dollars. They're limited, and we have dead trees all over Rankin County. And so this board has been aware of the problem and has been taking steps not only in-house to deal with dead trees, but we've made a major push in Washington, D.C. and at the state legislature to get help from the state and the feds to address dead trees. It's a serious problem. It's going to be with us for years. One drought is going to leave us with dead and dying trees for years, and the expense associated with clearing those dead trees just out of the right-of-way is enormous. We have to have help, and so we're doing everything that we can to get help. And I want to say again how much we appreciate specifically Senator Hyde Smith, who has consistently gone to bat for us to try to get funding. I wish that Congress could have gotten its act together 2 months ago and actually passed a budget instead of passing a continuing resolution. That was as much as they gave us. Well, all a CR did was kill our funding request. So Rankin County will get no federal funding for FY25 because Congress can't get its act together. Okay.
Yep, and I'd like to thank Ms. Brown and Ms. Brewer, for y'all taking time out and coming today and addressing us and doing it professionally, and I hope we answered your questions, and let people know we are here, trying to work with everyone, and thank y'all for your concern, and hope we helped y'all understand, some things, and just want to thank y'all for that. All right, Mr. Slay,
Well, I think there's one more that.
do we have another one?
Yeah, he's got his hand raised back there.
Okay.
Is this thing? Yeah, okay. My name is John Atkinson. I live on 314 Lakeside Drive in Brandon. Well, first of all, the trees, why not just make something where where people like her can agree it's okay for a minute to cut down this tree, but that's not what I'm here for. I'm here because I love Rankin County and I want to live in my county forever. And this fall, I am going to be moving out and going to college at Hines, like many other people, but I don't want a dorm. I want to own my place. I don't want to rent, all that kind of thing. I wanna like know that if like my funds aren't perfect, I go home, it's my property, I can be there. And for my needs, a manufactured house could be an amazing option. But the only commonly available like self-owned land, because you can have a zone, but if there's no land like zoned for it, are A1 and A2, which are just kind of like out in nowhere, and I don't want to live out in nowhere. And you can still only have the 7 years old thing. I want to be close to the river, the Natchez Trace, the parks where I work, study, and worship, and I want to live where there's like more neighbors, and I can take my dog to the dog park without like a lot of gas money and just draining me fund-wise to keep living out there. And there are other kinds of zones, like a manufactured housing district, which are for home parks in which spaces are offered on a rental or lease basis for owner-occupied manufactured homes, or in which the space and manufactured home combination are both offered to the public, all that kind of thing, on Section 2000 of the zoning ordinance. But this isn't a path to ownership. It's a path to an apartment that I own but still have to pay rent on. It is a path where private profit and government come together to zone an area to create a reverse rent-to-own scheme where I pay rent on my own house, and then they basically own it because I can't move it anywhere else in the county that I want to live in forever and contribute to forever. And there's the subdivision district, which does meet most of my requirements, except the way that it is phrased takes all of the dignity out of it. It is basically trying to say that it has to be located where there's not an adverse effect. Is my future an adverse effect? I want space between my neighbors and a large yard for my dog, and I want to afford that space realistically within a few years. And the title of this zone doesn't even consider it residential. Like, what message does that send? That the houses aren't meant to be lived in? That the people there aren't meant to call that place home? That these aren't places anyone should recognize as someone's home? More insulting is mixed residential zoning, because it proves that these rules are not about the public, individual, or environmental freedom or good, but about the freedom and good for certain freedom people who want to control the neighborhood. In the residential estate mixed REA1 zone, they have to be approved by community, manufactured homes have to be approved by community development, an appointed bureaucratic office controlling what houses are allowed to go where. Isn't your party the one that won this national election off of reducing unelected official making life-altering decisions, or is it lip service you use to give more freedom to your local bureaucracy so you can have the freedom to control, not help your neighbors? Additionally, Section 2200, that has residential mixed RMX zone, admits this goal by saying that this is one where several housing types are permitted, with sewage, lot size requirements like any other zone. But this is a one zone exception, not a principle that underlines all zoning laws. You cannot give any coherent argument to why all of these convoluted, overburdening laws exist to push small, affordable houses out of certain areas that many of you in this board live in, that is not about looking down on your neighbor and treating them as an enemy to you or your net worth when this code exists. If you say it's about safety, but don't put actionable steps and energy into creating law and order for the people in the zones you call unsafe, you don't care for those people. If you say it's about property value, but you don't care what these types of homes increased in value next to bigger homes, creating more value for the people who live in them, you don't care and look down on others' right to have property value. I don't want to live with only other people who have small affordable houses. I want all the kinds of neighbors with different amount of status and wealth. I want to live in a community in the real sense of the word with all different kinds of people. This zone option would be great, but there aren't really any of them.
Where are you wanting to live?
I don't know. There's I've seen properties where there's all of these they're not zoned right. They're just in areas where the zones are it's like a nice little area, you know?
The address you gave us, is that out there at the reservoir
There's all sorts of different, I've looked in Pearl, I've looked in around where I live, looked everywhere, and all of it's zoned for the big houses. Not all of it, but it's just looking and going and seeing all this, it just feels more and more, you know.
Mr. Slay, how long has the zoning been in effect, you know?
Since 2004.
Yeah,
It was
since
adopted in
2004.
2004.
So this
Okay.
is not something,
We've had-
this has been in effect since 2004.
Does that matter?
Yeah, it's been,
Yeah, it
it
does.
kind kinda does. You're acting like we just changed and made up
You
ordinances.
did just change. You just made up the ordinance of the 7-year housing thing.
Right, we
That
did that.
means that means that you've changed it. That affects people's ability to have freedom of movement.
Correct.
Could.
It does, not it could. It
No.
does.
No, they don't have to, as I mentioned,
We're not
nobody
here to
has to
argue.
move anywhere.
Right.
Nothing has to change.
But
We
you're
are
restricting people's.
addressing
Sorry.
the future.
You're
Gentlemen, we typically allow for public comments to be about 3 minutes, and then we need to move on to other county business.
They should have
so-
restrictions on your comment length.
Yeah.
Okay, I'm
Thank you.
done. If y'all don't want me, I'm done. Cause y'all are just trying to push me out here, right?
No, we
Thank you.
listen
We
to you.
listen
Thank you
to
for
you.
your-
but
for your
no,
time.
I'm-
Fine.
Okay, is there anyone else under public comments?
See that one front row right
Mr. Harvey.
Okay.
I really didn't come to speak,
Well, you-
I'm here.
Okay.
So I've been trying to get my
Can you
air
state your
property.
name first?
Ava Harvey,
Okay.
Dr. Ava Harvey. I earned it.
Good deal.
Pastor of the Pilgrim Rest Missionary Baptist Church on right there on Trickham Bridge Road. I live 897.
Thank you,
Y'all
sir.
may know me because I ran against Steve and he won. I congratulated him today. My comments are just basically, I've been trying to divide this air property that my grandfather left to my father that he has left to me. 7 acres. I've submitted 2 of these conditional use application forms for exception. I've pretty much put everything in here, but I did have a question about having to put on the deed no manufacturing homes and the exact size of the home that whoever gets our property in the family will have to have that on the deed. That seems a little unnecessary for
What's
me.
the zoning right now currently?
It's RE1, it's my understanding.
Residential estate, right?
So I have to actually have on the deed, the deeds themselves, that there can be no manufactured home, no modular home, and specify the exact size that someone may want to build later on in the future.
Well, it could be a minimum put, say, 1,600 or
And that has to be
2,000.
on the deed.
Yeah, I don't know, Mr. Slake.
Well, it's right here.
So-
Mr. Measles sent this to me, said deed restrictions stating no manufactured home sizes. That's a lot. I mean, that's asking me to forecast in the future what my grandchild may want to build, and I don't even have a grandchild right now. So hopefully I'll be alive whenever he or she comes.
Yeah.
I think that's a little bit overburdensome.
So Dr. Harvey's property is already zoned RE1. We don't allow manufactured housing in RE1. It's not allowed because of the zone. So
Right.
by having a deed restriction that clarifies that, it gives, the lady said, y'all don't tell us what you're doing and you don't give us adequate notice. This is a way, by way of the deed, to let any buyer of that property understand and know you're not gonna be able to put a manufactured home, not because the seller has told you that, but because the county doesn't allow the manufactured housing in RE1.
But whoever
Just don't allow
decides to
it.
do, if someone in the future, if it's ever sold, which I doubt it ever will be, that someone would have to go through approval, which is not gonna happen anyway.
Yeah,
So if it's zone RE1, it's a little bit duplicitous to say, well, hey, on the deed it says this too, when the zone itself is overarching.
It's all about protecting a buyer who may come into that transaction thinking, I'm gonna be able to put a trailer on this piece of property. And we're just making it clear, because it may be multiple iterations down the line. This may be the 3rd owner of the property after it's already been divided, who's now trying to sell. So it's preserving notice out into the future, by way of the deed restriction, there's not gonna be any manufactured housing on this particular parcel.
But doesn't
It's just-
ordinance
it's
do that?
extra. Yeah, it does, and this is belts and suspenders. And it's not unusual, we require deed restrictions all the time. This is a conditional use, we do deed restrictions as a condition. That's why that process exists.
I
If
get
you-
that, I get the point.
Right.
That you do have to have conditional use.
Absolutely. And
But
one of
it's-
our conditions is we require the owner of the property to imprint deed restrictions. And by the way, guys, we don't have to just do deed restrictions. We can reform that and make the condition that I'll draw up a set of restrictive covenants that applies to the property. And it'll say no manufactured housing, and it'll say minimum square footages. We can
But
do it
the
either way.
ordinance
We don't
does
have to
that
put it-
anyway.
Yeah, we don't have to put it in, require that it be put in the deed. It's just an easier way for the transaction to be structured to do it that way while
It's
the deeds are
easy
being drawn up.
it's easy for someone who does not have to go to a surveyor to get him to put this in every little bit.
But we can
If
take
you
that off the
divide it
table.
out, it's a lot.
But
It makes
we
it-
can change
It's
that.
a burden upon the poor people like me.
Let me address the board. We can
I
we can
finish
do
my-
restrictive
I gotta have 3
covenants.
minutes, please.
I mean, he's trying to answer your question.
But he's not talking to me, he's talking to the board.
Yeah,
My thing is, it's burdensome to the poor people like me, who have to now pay to go through an additional burdensome process to get specific things placed on every single deed if I'm dividing out air property. That's my point. So I didn't really get up to say that. I'm just here because I want to learn something. But thank you all.
Thank
for
you.
Right, thank you.
Let me talk to you.
Craig, and,
yes, sir.
so I'll understand. And community development, when you start dividing properties up, it's looked at as a subdivision.
Subdivision, yes, sir.
Subdivision.
That's correct.
A developer or whatever, and those type restrictions protect the community and the buyers.
100%. Not just the buyers, but also surrounding
It's-
properties.
It's really because it's being subdivided in subdivision
Yes,
with multiple units. So person
Yes, sir.
here knows what possibly could be next door to them.
right. So you're going from a situation where you have one housetop. In this example, you have 7 acres. My understanding is there's one house, right? The property, being air property, is potential of being subdivided depending on the health department's regulations with respect to lot size and what, I don't know what the sewer situation is out there, but at some point that will have to be addressed. So there may be some limitation on exactly how this property can be subdivided. But at the end of the day, you have the possibility of 6 more housetops out there. That's a fairly significant impact on what is currently a relatively rural area.
Well, currently, I mean, it's got to be more than an acre. I mean, it's got to be right
Yes,
at
sir.
2 acres.
That's correct.
So,
So it may be that this property is not subject to being subdivided at that level of density because the lots can't qualify by state and health department regulations as it relates to sewer treatment. But, you know, I don't know that's up to the property owner to try to figure that out. Before we get to the point where we allow for a subdividing, we require certain conditions to be met. And those are typically, you've seen it. You guys, every single one of y'all have seen it consistently. We require minimum square footages that typically is based on what is the square footage average of the surrounding properties. We do that to protect the neighbors. If you put a 1,200 square foot house next to a 2,800 square foot house, you are going to affect the property value of the 2,800 square foot house. So we try to be careful not to let the neighbors be affected by subdividing activity by introducing as a condition minimum square footages for the structures that will be on those parcels. That is not unusual. You have the authority under state law to address the condition and the property values of surrounding properties.
All right, is that all we got? Anybody else under public comments?
Everybody that doesn't have a 2,400 square foot home, are they taken into consideration too with neighbors? Because there's some people who I know do not have 2,400 square foot homes on Pilgrim Ridge Drive.
Well, I think that 2,400 was an example. I don't
Just
think
an
it was.
example.
No, it's not, it's actually required.
Okay.
But, you know, I don't know if you guys wanna go back and forth with this, but I can tell you for a known fact, on Pilgrim Ridge Drive, there are very few 2,400 square foot homes. They're manufactured homes.
Okay.
Those homes have been quote unquote grandfathered in. So I think if we're gonna consider surrounding neighbors, you also have to consider those poor neighbors like me.
Thank you.
Thank you all for your consideration.
Yes. Okay.
I'm Brian Atkinson. I live at 314 Lakeside Drive. I'm sorry my son had his rant today. I think part of what he's struggling with is he doesn't want 2,400 square feet. You know, he'd be happy with 400 square feet. And I don't understand how, I mean, when houses are sold, you know, price per square foot, how a smaller home negatively impacts a larger home. I mean, if it's kept up, you know, the appraisal is based on price per square foot, so what's it matter how many square feet it is? Can you please answer that question?
When I asked him where was he planning on living, I mean, he said he looked at Pearl. Pearl has their own
Yeah.
zoning and stuff, and I mean, we don't
Right.
control what Pearl does, or
Right.
the city of Brandon, or Floatwood, and I mean, it's just, I mean, I want him to live in Rankin County, I mean, and I think he deserves to live in Rankin County if that's where he wants to live, but far as the square footages, I mean, if he finds something 400 square feet, more than happy to buy it and live in it.
Yeah, I have a Katrina house, and I've been looking for a place to put it for about 8 months, and we just really haven't been having any luck. And he saw a billboard on Lakeland, and he got all excited.
Yes.
Came
Right.
down and, you know, just
Well, there's been
Didn't
a
have
lot
all
of
the facts.
misinformation
Yeah.
being put out there.
Yeah,
and,
but I really would like to know the answer to the question is why smaller houses aren't allowed. I mean,
Yeah.
people with fixed incomes don't necessarily need that
Well-
much house. And, you know, people just getting started don't need that much house.
Yeah.
Younger people today aren't placing the priority on going into debt. I mean, they have different priorities, and I think that our zoning and laws need to reflect that, so.
Thank you.
I think that's an excellent point. And gentlemen, your zoning ordinance, your comprehensive plan, both of those elements of that regulation, land use regulation, both of those elements are subject to being updated, improved, changed over time to adjust to economic realities. I think we all recognize that affordable housing is a real problem. We see it, we know it. We look for ways to address that where we can. And the challenge for us is to account for all of the considerations that are before us on land use regulation. The reality is you have pressure from those that are in the rural areas, the agrarian areas where you still have row crop agriculture, where you still have cattle cattle operations. In those areas, there's pressure to convert those into residential, and that pressure results in conflict. You've got the farming community that does not want to see dense residential development. You got the challenge of utilities not being able to keep pace with your development. And so we have to be careful about allowing for more dense areas of residential development where we do not have the infrastructure to account for that dense development. You have school systems that have to be accounted for. They have limited space. In fact, when they build new buildings, they're already out of space. We see it consistently. And so those are real challenges that sit on your lap, and you have more than just one or two considerations to take into account. There are a number of considerations that have to be taken into account. The public coming forward and addressing their concerns is one of those items that we need to be responsive to, but not in a vacuum. We have to think about all of the citizens of Rankin County.
Anyone else on their public comments? If not, Mr. Slade?
Gentlemen, my item is a matter that was brought to my attention by representatives of the Central Electric Power Association. I wanted to mention to the board that this relates to Stoll Road. Y'all may remember, I know Supervisor District 4 remembers, several years ago, we embarked on a process to improve Stoll Road, at least in part. And part of that process was to acquire additional right-of-way from adjoining property owners adjacent to Stoll Road, and then to improve that road. And I think, for the most part, Steve, it's now been completely overlaid.
That's great.
Yes, sir. And so it was a great project, a very needed project in that area of our community. And I'm grateful that we were able to accomplish that goal. As a part of that, what we ended up doing by expanding and moving is we impacted the public utility, the electric infrastructure that was already in place along that road. They are in the process now of providing for upgrades to their system. And so what they are looking at is to engage with the county on a cooperative process that will allow them to relocate a number of poles. If you drive along Stoll, you will notice that there are utility poles in very close proximity to what is now new road. The county's expansion of the pavement, the widening of the road, and the addressing of the stormwater management along that road has impacted where the existing utility infrastructure is located. So they're gonna have to relocate. What Central has come forward and asked for is the development of a cooperative process. Now, I may be springing some of this on our consulting engineer without having provided adequate notice, so hang in there.
Always a pleasure.
Yes. One avenue of approach for cooperation would be to allow for Mr. Parker to work directly with the Central Electric folks to make a determination of which of the utility poles are in the most risk of causing injury or an accident or anything like that. They want to get out of the liability business as quickly as possible because they are in close proximity to the road. Allow Mr. Parker to work with their folks to figure out where is a spot for relocation that makes sense, and allow for that to happen within new right-of-way, and enter into some sort of understanding with Central over time that to the extent that we further expand Stoll, if that happens in our lifetimes, and it could, that they will be allowed to relocate, but at county expense, not at their expense. I think that's a wonderful way to show cooperation with an electric utility. It shows that the county wants to work directly with our utilities and try to be a friend and a partner where we can, understanding as well that this area of Rankin County is growing and it needs additional electric utility supply. I think it's a win-win for everyone. What I would ask, and this is just for discussion, I'd like to take this up on Monday if the board's willing, but consider authorizing Mr. Parker to work directly with Central and try to come up with a plan and an arrangement that satisfies both the county and Central Electric to get this handled. Unless the board has a problem, we would just plan to have an action item on Monday's agenda.
Okay.
Mr. President, I would like to do that.
Okay.
I didn't ask Mr. Parker what he thought about it, so I'm assuming he's okay.
Mr. Parker he is good with it. All right, Mr. Hicks, County Administrator.
Morning.
Morning.
I have a couple of items. Item A is authorization for the board president to execute agreement for planning services related to our facilities contemplated as part of a future potential bond issue, and that agreement was with JH&H Architects to go ahead and start putting some buildings together.
I'll make a motion.
Second.
I made a motion, Steve seconded the motion. Any further discussion? All in favor?
Aye.
The next item is related to our Rankin County Justice Center chiller replacement. They've already started some light work and replacing some parts and pieces before the main unit comes in. It's due in a couple weeks. And we're asking for approval of pay apps 1 through 4. They were kind of sitting out there, we didn't know about them. They submitted pay apps 1 through 4. They've been through the engineer, and that amount is for $74,290. Authority to issue that check.
Make a motion. Second.
Scott made a motion, Brad seconded the motion. Any further discussion? All in favor?
Aye.
Motion carries.
And I'll remind you of our meeting on Monday.
All right, thank you. Okay, additional business. I've got one thing in additional business. Ms. Lay, you know, we're supposed to have a, hearing with the Southern Rankin Water,
Yes, sir.
and, if you enlighten us on that just a little bit?
Yes, sir. Actually, there was a resumption of a mediation that had already taken place and had been stopped temporarily to allow for the parties to figure out some information that was not available at the time we conducted the initial mediation attempt. And mediation, as a reminder, that is a voluntary process, non-binding, where parties who are already involved in litigation can sit down and discuss a potential settlement. Again, non-binding and voluntary, but it allows for the parties to stop the litigation, stop spending money on litigation, and talk about possibly resolving a case. That process was started, and then it had to be stopped because there was some specific information that we didn't have at our disposal at that time. So the agreement was we will continue the mediation. We will just simply delay it until we have that information, and then we'll regather. The delay has been extraordinarily long, over a year since the initial mediation. So it was finally rescheduled for yesterday. 2 days before the mediation, we get an email from one of the attorneys for Southern Rankin Water Association demanding certain documents associated with the road project, that they could not participate in the mediation without specific documents that they demanded. And so, out of an effort to be as cooperative as possible, even though the document that they asked for is not typically available until the project is concluded, we're still working on Gunner Road, by the way. And so that project is still incomplete. Our engineers moved heaven and earth and got the document that they demanded and got it to them on the 29th, 2 days ago. They, after receiving it, they wrote back and said, well, you got it to us too late. So we are not going to participate in the mediation.
Okay, what can we, to move forward?
Yes, sir.
Can we just let turn it over to the courts and let the judge decide what not the agreement at one time?
Yes, sir. That is an option that's available to the board. Again, mediation, I'll remind you, is voluntary. You don't have to do that. And so because it's voluntary, you can choose not to participate any further in attempts to mediate this case. And you can instruct your attorneys to immediately secure a trial date.
Did they offer an alternative date since they got
No.
No. So they just said we're not meeting.
We're not mediating.
Okay.
I would say go ahead and let's get us a trial date.
So-
With your permission, and not to belabor the point, I will communicate to our litigation counsel that we desire a trial date as soon as possible on the court's calendar, and that we prepare ourselves to be at trial on that date and asking the court to enter a judgment in favor of the county.
Okay.
Is that
Yep,
the instructions that I have been given?
correct.
I will carry those out.
All right, thank you. Any other additional business? Okay,
Do we have a need for executive?
Yes, sir. We have a number of bases upon which to be in executive session. I will list them. We have a matter of personnel, we have a matter of pending litigation, and we have a matter of potential property acquisition. Mr. Dare is here to visit with the board concerning potential litigation matters, and I'll have some other things to talk about as it relates to some pending litigation that we have. So those would be the bases upon which you should deliberate concerning whether or not to go into executive session.
Make the motion to discuss the need for personnel, litigation, property acquisition.
I'll second.
Steve made a motion, Brad seconded the motion. Any further discussion? All in favor? Aye.
Now I make a motion to go into executive session for those reasons.
And I'll second that motion.
Steve made a motion to go into executive session. Brad seconded the motion. Any further discussion? All in favor?
Aye.
Aye.